Good evening, everybody. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ನನ್ನ ಹೆಸರು ವಿನಯ್ ಶ್ರೀನಿವಾಸ ಅಂತ ಆಲ್ಟರ್ನೇಟಿವ್ ಲಾ ಫೋರಮ್ನ ಸದಸ್ಯನಾಗಿದ್ದೀನಿ. My name is Vinay. I'm a member of the Alternative Law Forum. ALF is a collective of human rights lawyers, and we are working to make sure that our constitutional values take root in some small way. For today's discussion, I'll just hand it over to Amir to introduce the speakers and get it started.
Thank you all for coming. This is an event that has been made possible in collaboration with a number of institutions. This is the 58th public lecture series by the NCBS Archives, along with the Queer Archive for Memory, Reflection and Activism at the National Law School. And we are very happy to have it at ALF. We have long friendly associations with ALF. Let me introduce our subject today and our speaker, Shomona Khanna. So today's talk will bring attention to struggles for recognition of forest rights and for democratic forest governance in India. Shomona Khanna will be speaking from the perspective of a lawyer about the many ways in which social movements have laid claim to the law, both as a shield against evictions from traditional homelands, as well as a sword to advance customary rights. So she will focus on key moments from popular mobilizations around the Forest Rights Act over the past 2 decades, and we've asked her specially to bring some records of archival importance. This is of interest to both archives at NCBS and the Kamra Archive. And so she will play some audio-video clips. She will circulate, I think, also excerpts from reports. She will speak about Gram Sabha resolutions and show us some pamphlets. These tend to be lost quite easily. They are part of fragile memory, so we're very happy to have them with us. The conversation will historicize the present moment of rollback of rights and will interrogate methods of human rights lawyering that can enable us to hold our ground. So a little bit about Shomona Khanna. She's an advocate practicing in the Supreme Court of India and the Delhi High Court. She's been associated with numerous civil and democratic rights issues since 1991 as a lawyer and as a writer. Between 2011 and 2017, she was legal advisor to the Ministry of Tribal Affairs, Government of India. She handled several human rights cases in the courts, including the abolition of manual scavenging, protection of women from sexual harassment in the workplace, and indigenous people's rights. She's written several books and book chapters. Importantly, in 2017, she initiated the Legal Resource Center, a collective of lawyers and legal professionals engaged in demystification of the law for indigenous and Adivasi communities through legal workshops, training materials, academic and action research. And as part of these endeavors, she has spearheaded the development of a 17-part audiovisual course entitled Critical Learnings on Forests and Adivasi Rights. So very happy to have you with us, Shomona. And our discussant today is Radhika Chitkara, who is assistant professor at the National Law School, where she teaches criminal law. She's also a doctoral scholar, a clinical practitioner and activist in the field of human rights, civil liberties and land rights. She's also been associated with the Legal Resource Center. She has been part of the Jindal Global Law School and the National Law University, Delhi. She received her LLM from the Harvard Law School and completed her BLLB from NLS, Bangalore. So we look forward to the talk and all of your sharp questions. So shall we begin? Radhika, do you want to say something?
Yeah. So thank you to Kamra and to NCBS and to ALF for organizing this talk. I'm very grateful for the opportunity to have this conversation in this time and place for 2 reasons. One is, of course, it's an opportunity for us to bring all of our deliberations from Janpura to Infantry Road over the past 6-7 years. But also because as we sit here today, we're also resisting major setbacks to the struggle for forest rights and for democratic forest governance, all of which have been hard-won victories. One can go back in time to the past 250 years. But if we're talking specifically about laws like the PESA or the Forest Rights Act. We're looking at a history of at least the past 20 to 30 years. We're looking at particularly the dilutions in law, the changes to the Forest Conservation Act. We also want to acknowledge the ongoing struggles in Niyamgiri, Raigada, Kashipur and Orissa, where we're witnessing severe repression against human rights activists as we speak. And with that in mind, very grateful to be here to sort of canvas the history of the past at least 20 years of what the struggle has looked like. As lawyers working in the field of forest rights or land rights, we often turn to the law, turn to our constitutional guarantees, albeit with a little circumspection, little skepticism sometimes. Guarantees of equality, guarantees of civil liberties, the fifth schedule to the Constitution, which protects the right to autonomy and self-determination over traditional homelands. We look with optimism and hope towards statutes like the PESA and the FRA, which have been the outcome of democratic struggles over the past many decades. And all of these are ways in which social movements lay claim to the law to articulate rights of self-determination, of autonomy over Jal Jungle Zameen. And while this act of laying claim to the law might appear fairly ordinary to many people in the room, given the context of the struggle for Jal Jungle Zameen, we believe it's nothing short of a massive leap of faith and a demonstration of heroic courage as well. Because once we begin to canvas this history, we notice that, law and violence are not two different things or two, separable parts of this kind of oppression and dispossession. That it's historically it has been the law that first established eminent domain of the state in an attempt to expropriate land and resources. It has been the law that set up oppressive institutions like the police and the forest department in Adivasi areas or forests. It is the law that displaces, it is the law that dispossesses, it is the law that enables diversion of forests for mining, ironically, under a law called the Forest Conservation Act. It's the law that criminalizes identities, criminalizes belief systems, criminalizes livelihoods, cultures, and civil liberties, right? For Adivasis and forest dwellers across the country. So I think the question that I would want to pose to Shomona for this talk then is, how does one do lawyering in a context where the law is not your friend? Yeah. And I hope as we journey through these past 20 years of lawyering for forest rights through these sort of carefully curated materials, archival materials, Shomona can also remind us of the significance of these struggles for our environment and for our larger democracy, and the need to continue fighting over these contested terrains with even more urgency. So with that.
Thank you so much, Radhika. Thank you, Amal. And thank you all of you for being here. I'm really feeling a little puzzled because it's difficult, sometimes to talk about your work and look at it like this, the way Radhika's put it. I don't know. Have we been doing all of this? I don't really know. But we can just go to the next slide, please. So I just want to begin today because we're talking about lawyering, but it's really important to start the conversation on lawyering with this very iconic photograph. I'm sure most of you have seen it. I don't really know who took this photograph, but it's from the Chipko movement. And way back in the 1970s, women in Uttarakhand, there was no Forest Rights Act, there was no PESA at that point of time. And women in Uttarakhand decided that they're not going to allow the government to cut their trees. And it was a very repressive situation. Many of them found themselves wounded, they found themselves on the wrong side of the law. But this actually is an integral part of the process of lawyering, so I thought, let me put this right in front. If we can go to the next slide. Just to give you an idea of the extent of the issue, it's 100 million people who live on land which is classified as forest land in India. 107, I think some part of it is getting cut. But anyway, 170,000 odd villages of the 587,000 villages in India, with a population of 147 million people, are located in and around these forests. Now please remember that this is 2011 census data. We don't have 2021 data. So it's probably much more now, but we have to go with this information. And some estimates say that it's a 275 million to 400 million forest dependent people in our country. That's really a lot of people that we're talking about, and it surprises me that it's a subject that so few people know so little about. And 4,500 forest villages are there, which is basically villages which are inside forests. They are not recognized as revenue villages, so they do not have access to basics which an ordinary revenue village would have access to, like water, PHCs, roads, electricity, things like that, and they cannot even ask for those things. Interestingly, many of them are on the voter lists. So, so they are eligible to vote, but they are not eligible to ask for drinking water. And also in terms of the area of land, there is a conservative estimate which was done by colleagues of ours. Out of 71.37 million hectares of forest land in India, approximately 40 million hectares of land is potential areas where forest rights ought to be recognized because people are already there exercising rights. So, no, don't move to the next slide. So, I just wanted to a little glimpse into the Indian Forest Act of 1947, which was a colonial legislation, and it basically created government forests in the name of reserve forests, protected forests, etc. Through fiat. But there is a procedure in this law and also other laws that resemble it relating to wildlife conservation and so on. So they have a procedure because the British always like to have, do things the right way. So there's a process for the settlement of rights. But that process, if you read it carefully, it is basically that they will issue a first declaration that we intend to declare this as a forest, and we have appointed this forest settlement officer. Anybody who has rights in this land to please come and apply and make your applications. And if you don't come within 90 days, then your rights stand extinguished. So I'm just wanting to point out that look at the number of the area of land and the number of people whose rights have been erased through what is essentially a legal fiction. And from that moment onwards, after the forest is finally notified, it brings a lot of the very, very harsh provisions of the forest law into operation in that area, including very harsh criminal law provisions, which means that anybody who is cultivating that land or anybody who's gathering forest produce from that land, grazing their cattle, all of which are part of the normal lifestyle of forest dwellers and indigenous communities, are now committing crimes. So they're criminals in their own lands through a legal fiction. So this is the reality, and but there continue to be people who have very little interaction with the state until the state needs those lands for something else. So the number of cases that one has come across where people have said that we only came to know that this land has been declared as a reserve forest or a national park when they decided to divert it for mining or for a factory or for some other project like a dam. And then we came to know that 20 years ago it was declared as a wildlife sanctuary, and on paper they said we set up all these officers and all, and nobody came. So your rights have been extinguished, now you get out. So in the 80s especially, there was a little bit of a change in terms of how forests are looked at from the lens of conservation, that we need to protect our forests and so on. And the Forest Conservation Act came in 1980. And in 1995, very interesting case started in the Supreme Court again through a letter petition called the Godavarman case. Many of you have heard about it. I know there are people here who have suffered that case. So the Supreme Court was passing orders in a continuing mandamus relating to forests and protection of forests and so on and so forth. And nobody, even in the forest dwelling communities, people didn't know that there's a case like this pending. Until in 2002, May 2002, there was an order issued by the Ministry of Environment saying that the Supreme Court has passed an order saying that within 9 months, all the encroachers in all the forests in the country have to be evicted. So now you can move to the next slide, and I'll just show you that if you can click on this hyperlink on the top. So this is the order that came. Are Bapre? So basically the ministry has worded it in a very smart sort of way. So if you read it as a lawyer, they haven't actually said anything. No, not this one.
Not this one. Order 35/2002.
Yeah, this is the one, and it's been issued to all the. You can just keep it here. It's it. To all the chief secretaries and secretaries, etc., of all the states and union territories, basically saying that on 23rd November 2001 in IA number so and so, writ petition so and so, that is the Godavarman case, Supreme Court has passed an order, and this time-bound program for eviction of encroachers. Okay. So I was a young lawyer at that time, and sort of going about here and there, and some people from the forest rights movement approached me, as they would another lawyer, and they said that, can you find this 23rd November 2001 order, because we want to challenge it. How has the Supreme Court suddenly passed an order saying evict all the encroachers from all the forests? So I did the usual thing, asked around, and those days we didn't have orders which used to be uploaded. So I asked a few friends, and they said, oh yeah, I'm also in that case. I said, can you see if you have a copy of this order? And then when I looked at that order, it said you can actually go to that order. It's quite funny. This is the next document. Order dated 2311. Basically, it's.
This is the Godavarman order. Right?
Yeah. No, not the IA.
This 23.
Yes. So this is the order. It says an application has been filed by the learned amicus against illegal encroachments and issue notice to the respondents, returnable so and so, interim order in terms of prayer A. Now I was in a fix. I said, I don't know what is this prayer A. So, and that lawyer said, this is not my matter. I don't know anything about it. So we don't know what is prayer A. Now imagine the Supreme Court has passed an interim order, something to do with eviction of encroachments of these millions of people, and has passed an interim order in terms of prayer A. So then I, literally went to the amicus's office and said, I represent so-and-so organization and I want a copy of your IA. I think they probably just didn't know who I am or what they're getting into. I was a pretty unknown person, and you can move to the application, the one that you had put before, and then got a copy of that application and found that prayer A. If you can just scroll down to the prayers part. Yeah, there it is. Prayer A. Yeah. What is prayer A? Prayer A is restrain the union from permitting regularization of any encroachments whatsoever without leave of this court. And this had been represented by the Ministry of Environment and Forests as an order to evict. And I mean, seriously, that is the beginning of my sort of, although I had been working on the issue of forest for a very long time, but the sheer injustice of the opacity of, first of all, so-called public interest petition, and the way in which it can be misrepresented in such a mischievous manner. And the sad part of it is that they had actually started evictions. So if you go to the next slide, which is slide number 5, you will see that we have, for the last year and a half, I've been trying to get photographs or any kind of information from that time. And the only picture that we've been able to find is this one, but there are, the movement is replete with stories about how the MOEF did not waste any time in moving into tribal habitations in, especially in the Central Indian tribal belt. They moved in with police, paramilitary, and with elephants, and just basically plowed down their houses and set fire to their crops. So 300,000 tribal people, it is estimated, were actually evicted during that time. So as a lawyer, when I was able to obtain these documents, it seems like such a simple thing, but giving these documents to the people in the movement, and then there was just a complete conflagration, because people said that this is just so wrong. In plain black and white English, you can read that what has happened is completely wrong. And so on two levels there was a change. One was, of course, that the usual thing of a lot of sangathans, a lot of NGOs, a lot of interested individuals. They filed applications in the Supreme Court for modification of this order, and also to tell the Supreme Court what has been going on, what the MOEF has been up to. But those applications are still pending. They have not been heard till today in the Godavarman case. IA 703, etc., are still pending. But the other thing that what happened was that because there were a lot of movements for recognition of forest rights in different parts of the country, in different shapes and forms, and they had managed to actually make progress in states like Maharashtra, etc., Madhya Pradesh, etc. But they were sort of separate from each other, they were fragmented. But this particular experience, this incident this entire exercise actually brought all these movements and disparate groups together, and they federated under what here it is the Campaign for Survival and Dignity, but a lot of other organizations also formed. And this was one of the first Jan Sunwais. I was fortunate enough to have attended it. Again, no photographs. And this was a document that came out of that Jan Sunwai. And I have one of the last surviving copies of it, which I've just scanned. And it has all the narrations of all the things that happened as a result of the Supreme Court order, but also in terms of bringing people together, and they were telling stories to each other and realizing that there is this commonality of experiences with the Indian Forest Act, the Wildlife Protection Act, with the Forest Department, with what they face, what are the kind of strategies that the Forest Department faces, exercises. if you can move to the next slide. There was a lot of mobilization across the country. This is one photograph that I had from my own sort of little camera, which then I got digitized. But it was truly remarkable to see the way in which people were getting mobilized. Like, this is just a very small view, but there were, like, I think at this particular meeting maybe 7,000 people. And for some 20-30 kilometers the roads had been blocked and people were walking or cycling into this particular rally, and there were rallies like this across the country, and they were asking for a simple thing, that we are not criminals, we are not encroachers on our lands, and we are no longer satisfied with the kind of piecemeal solutions that you're giving us. Here we'll recognize 5 forest villages, there we will issue some circular where we will regularize encroachments, somewhere else we'll do something else. We don't want this. And by pretty soon it became, they were very clear, they wanted a standalone law. A standalone law that will compete in the framework, sort of mainframe laws with the Forest Conservation Act, the Indian Forest Act and all the Wildlife Protection Act. We want a law like that. And so in early 2000, there was a meeting, this has been written about, so I can tell you about it. It was a meeting in the office of the then Prime Minister, and 2 decisions were taken, very important ones. One, of course, was that a legislation needs to be made for recognition of forest rights, and it will be a central legislation. The second decision that they took, which was equally important, was that this legislation will not be under the Ministry of Environment and Forests. It will be under the Ministry of Tribal Affairs. And they went and did the due diligence of amending the allocation of business rules, so that the authority to, or the executive authority over the Forest Rights Act would be with the Ministry of Tribal Affairs. And I mean, Ministry of Environment and Forests, as you can imagine, was not happy about that. And then the drafting process started. I won't get into the details of that drafting process because all sorts of ups and downs we had. But if you can go to the next slide, I'll just show you the, no, there's just another slide. No?
No, this is the
Oh yeah, okay. Yeah. So what actually came initially in 2005 was the Scheduled Tribes Recognition of Forest Rights Bill of 2005. It was placed before Parliament. And there were lots of problems with that bill. And these are just 4 of them that we see that are really important. One, they had restricted it to tribal communities. And as many of you will know that the project of scheduling of tribes in India, although we tend to use the term scheduled tribe and indigenous people interchangeably, but that's not the case entirely. There are lots of people who have been left out of the scheduling process. There are many tribes who are scheduled in one state and not scheduled in another. There are tribes that have been scheduled in one part of the same state and not in the other. So the exercise is not complete. And what the movement clearly realized is that if this law is restricted to the scheduled tribes as notified under Article 342, then the movements will disintegrate, because they have been cohesive till now of all forest dwellers. So the need to include other traditional forest dwellers was immediately a point. Then there was this other thing that there was a provision. In fact, when I was looking at this to prepare for today, I was looking at it again and I was literally horrified all over again to see the section 7 that they were proposing, where they said that if rights are granted and the forest dwellers don't look after that land in accordance with forest conservation principles and all, then their titles can be taken away. And this was another provision we fought to get removed. And then of course there were provisos to the vesting of forest rights, that it would be conditional on various things. And one of the things that was not there which is there in the law as it exists now, is joint titles for women, which has been extremely powerful. So what happened was that, of course, those days lots of very healthy debates used to take place in Parliament. So the bill was referred to a joint parliamentary committee. That's also there actually in the documents, but just to give you briefly, it was chaired by a very senior parliamentarian, Kishore Chandra Bhyo. Very, I mean, as a person who understands what tribal life, and he himself is a tribal but also very educated and very empathetic person, very unpolitician-like person, very cool. And so it had a very large membership, 29 members from the Lok Sabha and Rajya Sabha from all political parties, and they did extensive consultations over a year and a half, 109 written memoranda, 44 oral depositions, and all the details are there in the GPC report. It's really, and pulled out all the things and suggested the revised Forest Rights Act, which we today know as the Scheduled Tribes and the Other Traditional Forest Dwellers Recognition of Forest Rights Act. Now, if you go to the next slide, skipping very quickly here, that the amended bill in its present form was passed in the end of 2006, December 2006, but it was brought into force only a year later on 31st December 2007. So during this time there was quite a lot of public opposition in mainstream media. And there was, I still remember being sort of, every other day waking up to read the papers, and there was this completely nonsensical, so those days we didn't have the hashtag, but if it had been a hashtag, it would have been hashtag tribal versus tiger. And every now and then there would be this, all the tigers will vanish, and all the tribals will cut all the trees in the country, and all this. And there were actually organizations that had made advertisements that were coming on television, which were like, there would be a tiger moving through the sunset, and this is the last time you see, your children will not see a tiger, that sort of thing. So anyway, this act came, it was in force, and I just want to show you this because it was such a joyful moment for us. So the next slide is the preamble, and it's a really important piece of legislative drafting, because definitely I think at that point of time it just made us feel good, but over the last 15 years what one has recognized is the importance of the preamble as an internal tool for interpretation, because the stories that we have, those we'll do another day perhaps, about how the administration, how the forest department has taken out little provisions in the act and has misinterpreted them, turned them on their head, and how we have had arguments with them, always turning back to the preamble. But three things that I want to just tell you that are so vital. One is an acknowledgement by Parliament that there has been a historical injustice against tribals, which in our country at that point of time was the first time. Subsequently, there have been other occasions when Parliament has acknowledged historical injustice, but this was the first time, and also acknowledging that they allowed this injustice to continue after independence. And the last paragraph actually says that there have been people who have been illegally removed from their lands due to state development projects. This again is an extremely vital acknowledgement, because if you look at data, it's from the time of independence to now, not now actually, 2002. Again, you know how data is becoming difficult to access in our country, but 40% of the people who have been displaced due to developmental projects are tribals. Their percentage of population is 8.5%. So when people say that tribals have borne a disproportionate burden for our modern industrial democracy, let's just say that, oh God, it is true. 40% is a very big difference from 8.5%. So that is one. The other thing that's really important is that the law acknowledges that forest dwellers are integral to the forest ecosystem and are vital to its conservation for future generations. And this was a pretty revolutionary thing for the legislature to say at that time, because the Wildlife Protection Act actually said the exact opposite. And the way in which the wildlife conservation was being done at the time was that if you can only conserve if you remove, at least from the state. Already by then there were people, scientists and people who were saying that conservation and people have to go together, but the state was under this insisting that it has to be only by removing people. You have to create these excluded areas, the fortress conservation approach. As you can imagine, there was intense resistance to the Forest Rights Act even before it actually came into force. And pretty much by the middle of 2006 we knew that there are going to be challenges to the Forest Rights Act in court, and we started getting ready for them. And sure enough, within 8 to 10 days of the act coming to force on the 31st of December 2007, early January, the first writ petition was filed in the Supreme Court. Subsequently, there was another petition in the Supreme Court. There were around 7 writ petitions in different high courts. And interestingly, most of these were not challenging a specific provision or some specific provisions. They challenged the entire act as being violative of the fundamental rights chapter of the Constitution. And that's also an unusual thing to happen. And I think that basically it was a certain wildlife conservationists, retired forest officers. There has been very open antagonism against the Forest Rights Act by sitting foresters, but they could not, of course, go to court directly because as the sitting officers you cannot challenge the law made by Parliament. So they roped in their retired forest officers associations with people who are like in their 70s and 80s. So that was one thing they did. And third category of people who went to court against the Forest Rights Act were former zamindars, saying that these forests belong to my ancestors and we looked after them so well, and look at these tribals, now they're going to get these lands. So initially what happened right in the very beginning, because the way in which these matters were argued and also represented before the court that tribals are going to cut down all these trees, one of the things they actually argued and calculated and told the court that every single tribal family is going to get 4 hectares of forest land and they're going to cut those trees, which is of course a lie. It's a wrong, it's just a completely nonsensical statement. But so initially from some of the high courts there were these ex parte stay orders on the implementation of the act, but the central government got into the act very quickly, plus tribal organizations and the people from the movement across the country, they included themselves in these petitions. And very smartly, none of these people thought it's necessary to make a party respondent any Adivasi organization. Imagine if you and I ever did this in a civil suit. The party whose land we are planning to take away, we don't make them party. You get nicely wrapped on the knuckles by the civil judge, right? But in the Supreme Court and the High Court, they didn't think it necessary. And people had to come and file implement applications and come on board. And of course fought tooth and nail and got those interim orders set aside in most cases, and in Tamil Nadu it was modified so that there was some court surveillance had to happen. But in the Supreme Court there was no stay, absolutely no stay on the implementation of the act. But in spite of that, over the last 15 years there has been continuous obstruction from the Forest Department, from the Ministry of Environment. And forests are being diverted at a crackling pace in this country. There are news reports that say that in the last 5 years, the forest diversion in India has been the second highest in the world, second only to Brazil. And considering that compared to many other countries, we are a fairly small country in terms of land mass, that's a really shocking state of affairs. But nevertheless, because there was a lot of this forest diversion happening, and you know how there are always countervailing forces inside the government. So the Ministry of Environment and Forests itself in 2009 July issued a circular saying that you cannot divert forest without Gram Sabha consent. And basically what this means is, it's very simple logic, that there is a Gram Sabha, a village community that has historical rights in this forest, and whether their rights have been recognized or not, whether they are in process or not, whatever the situation may be, if you're planning to divert this forest for a non-forest purpose, for mining or whatever else, a dam or whatever, then you need to ask them. They have to say yes. So it's a simple matter, but it took a lot of effort to get that circular out. But once that circular was out, then across the country, people had started already demanding that you have to ask us, and if you haven't asked us and already diverted the land, then you now ask us, and we will say yes or no now. And if you issued the forest clearance, you have to take it back. So I just want to talk a little bit about the Niyamgiri case. Are we doing for time? Okay. So then many of you must have heard about the Niyamgiri case, about the Dongaria cones who eventually won. And there was this beautiful judgment of the Supreme Court in 2013 where they said that they actually have made it now the law of the land, that if there is the forests of the tribals are being diverted for any other purpose, then they have to be part of the decision making process and you have to get their consent. This principle has now entered into all sorts of circulars and judgments of the NGT and different high courts and other areas of law also. It's become a law in India. And what happened with that case before that beautiful judgment is that it was, I think, around 7 or 8 years of legal battles where they continued to lose, and they lost and they lost and they lost, but they never gave up. So I think working with marginalized communities, if you're talking about lawyering, one of the things that you learn from the poorest of the poor and the most marginalized communities is that giving up is not an option. So if they've decided to fight, then the fact that you have lost the case, that's not necessarily the end of the story. So as a lawyer, you have to recognize the fact that, we get, okay, this matter is being dismissed. We say, okay, this is the fate of the matter, and we move on to the next matter. But they don't move on, they come back again and again. So they kept coming back with new kinds of challenges, and eventually they won. So I find it very interesting that they didn't give up, where, many lawyers like me, lawyers like you would have given up. But it's also important to recognize that after the Supreme Court judgment, I just want to show you that judgment. I forgot to change the slide.
Next slide.
Next slide. Yeah, the slide. So there's a very beautiful quote here, and coming from a 3-judges bench of the Supreme Court, if we can just read only the underlined part, it says, of late we have realized that forests have the best chance to survive if communities participate in their conservation and regeneration measures. The legislature has also addressed the long-standing and genuine felt need of granting a secure and inalienable right to these communities whose right to life depends on right to forests, thereby strengthening the entire conservation regime by giving a permanent stake to the scheduled tribes dwelling in the forest for generations in symbiotic relationship with the entire ecosystem. So these words are very powerful. Many of us don't actually study this judgment in our law schools and all, but believe me, when you talk to tribal communities, they all know about it. And after this judgment of the Supreme Court, the Gram Sabha meetings were held. It was very interesting because the court had also directed that a district judge, I think it was the district judge Raigada, who went, it was monsoon and he had to wear a bulletproof vest because he was very scared of the Naxalites, it seems. So he walked through those jungles and reached every village, and every village unanimously voted to say that they want to protect their hills and they don't want to divert them. And eventually the forest clearance had to be cancelled by the central government based on the decisions of these Gram Sabhas of Dongaria code, who are a particularly vulnerable tribal group. So we just want to share with you a little clip of that, a beautiful film that has been made documenting that entire process, and it's called Referendum, which is sweet. And these are the people. They are, yeah, you can see. They're speaking in Urdu, but there's a English subtitle.
हेले किछि भी कहवा सहज नथिला। चारिपटे भयर वातावरण, वेदांत को विरोध न करिवा पई धमक, सबु किछि बेखातिर करी डंगिरिया माने आज एकजुट होइछन्ती।
उक्त सभारे शेरपापाड़ी वार्डर सद्य श्री राम बरडियांको सभापतित्व करथिले। मान्यवर उच्च न्यायालय ओडिशा निर्देश क्रमे रायगड़ा जिलार मान्यवर जिला न्यायाधीश रायगड़ा पुलिस सभार पर्यवेक्षक रूपे उपस्थित रही। सद्य बैठक में कोई भाषा उद्बोधन देले जे नियमगिरी जंगल और देवता को छाड़ी कौन डंगिया रही पार ना, तेणु से जंगल को कौन सरकार कि कंपानी को दे पार ना प्रकाश कले। दंडु शिकका सद्य बैठक में समस्त को नियमगिरी जंगलर खुंदा पानी और विभिन्न खाद्य जिनस मिलूँ से जिनस को बिक्री बता खाद्य रूपे ग्रहण कर नियम राजा देवता को प्रथम पूजा करते, तेणु कौन सरकार कि कंपानी को अनुमति देवे ना कहले। जदि सरकार कि कंपानी जबरदस्त नियंती तेरे समस्त डंगिया मरी पचे छाड़ू ना प्रकाश कले।
केतरा छाड़ी आज्ञा सब संपूर्ण दे ना ये सब मैं बनी से केते एकर अछि केते अछि से कम दे
बुझलो तुम ठीक है बुझले हो ना नेहरा तमरो गोटे जंगल कमिटी तुमको तुम दाबी करथिलो एलाको सेलाको देखिथिले लेते कि तुम स्पेशल रोड तुम देखिथिलो दाबी करथिलो तुम जेरो एकर छोड़ा तापर बोलानी बुझी देखिथिलो एनु कला झरना देखिथिलो तो दाबी परमति दोचरे राष्ट्रीय ସବୁ ଯେତେକ 16ଟା ଏଠି 16ଟା ବି ଲେଖାଛି ତମେ ଏଗୁଡ଼ାକ ଦାବି କରିଥିଲ ବୋଲି କହୁଛି ରିପୋର୍ଟ
ଗାଁ ଉପାୟର କଥା ଥିଲା ଅଣାବଟା ଦେଖେଇ ନାହିଁ ଅଣାବଟା ଏଠି ଦେଖେଇ ନାହାନ୍ତି ଅଣାବଟା
ଅଣା ଫଣା କ'ଣ
ଆମର ଶ୍ରେଷ୍ଠ ସେଠି ପୂଜାସ୍ଥଳ ସେଟା
ଅଣା ଫଣା ଇଏ ଲାଗୁଛି ନିୟମିତ ଅଧିକ ଆଲତୋ ହଳାଇବ ତାଙ୍କେ ସିନା ଦେଖିନାହାନ୍ତି ଏଠି ଯାହା ଦେଖିଥିଲ
ଲାଗି ପଡ଼ିଥିଲେ କିଛି ଅଫିସର ସରଳ ଡଙ୍ଗିରିଆମାନଙ୍କୁ ଭୁଲ ବାଟରେ ନେବା ପାଇଁ। ବୁଦ୍ଧିମାନ ସେମାନେ ପ୍ରଥମରୁ ହିଁ ବୁଝିଗଲେ କଥାଟି କ'ଣ। ପୂର୍ବରୁ ମିଛିମିଛିକା ଜଙ୍ଗଲ ଅଧିକାରକୁ ନେଇ ପ୍ରାୟୋଜିତ ପ୍ରସ୍ତାବଗୁଡ଼ିକୁ ନାକଚ କଲେ। ଲୁଚାଛପା କିଛି ନାହିଁ, ସବୁ କଥା ସ୍ପଷ୍ଟ ଭାବେ ସମସ୍ତଙ୍କ ଆଗରେ କୁହାଯିବ। ସବୁ ନିଷ୍ପତ୍ତି ଗ୍ରାମ ସଭାରେ ହିଁ ହେବ।
ଗ୍ରାମ ସଭା କରିବା ବୋଲିକରି ସେ ବୈଠକଟା କୁଟୁମ୍ବରେ ଯେନ୍ଟା ବସିଥିଲୁ ସେତିକିବେଳେ କେଶର ପାଡ଼ିର ଗୋଟେ ପ୍ରମାଣଟା ପାଇଲୁ ସରକାର
Yeah, just one thing. So this just a little glimpse of how and these kind of Gram Sabha meetings were held in all the villages, and very interesting to see this kind of footage in which the villagers were actually feeling that sense of confidence to have these kind of arguments with a district judge, and he's also listening to them and not scolding them the way sometimes they would scold us in a court. But that was very and they kind of really managed to sustain it. Those 3-4 weeks when these Gram Sabha meetings were going on were very tense for us, because we were like, if one Gram Sabha says yes to this project, then what are we going to do as lawyers? But fortunately they all unanimously said no. But subsequently things have not been all hunky-dory. I think Radhika will tell a little.
I just wanted to take 2 minutes to offer an update on what's happening in Niyamgiri, Kashipur, Raigada today. So you will see that the judgment of the Supreme Court came out in 2013. It's been 10 years since then. Over the course of this time, there have been many moves to sort of roll back the rejection of the project by the Gram Sabhas. So early on, the MOEF mobilized to challenge this judgment even after the Gram Sabha verdicts were where the Gram Sabha did not give consent, saying that they had exceeded the mandate that the Supreme Court judgment had given them, that they did not have the power to say no to the project, but they only could say whether or not the project conflicts with their cultural rights. Just by way of background about the project, this is about a bauxite mine in the Niyamgiri hills by Vedanta. At the time, what had happened was that very, again, law and its many diversions, etc. The corporation had projected the bauxite mine as a separate project from the refinery where the ores were supposed to be processed. And then they managed to get environmental clearances based on that. The point at which this judgment intervenes and the Gram Sabha resolutions were passed were the point at which the refinery in Lanjigarh had already been set up, but sitting mostly defunct because the ore that it's meant to extract is not possible anymore because of the Gram Sabha resolutions. So what happens over succeeding years in 2017 and 18, there is an escalation in police and paramilitary deployment at the base of the Niyamgiri hills, setting up of military camps, and there was even a firing at the gates of the Lanjigarh refinery which had led to the death of 2 workers. The organizations that had been mobilizing against the mine, specifically the Niyamgiri Suraksha Samiti, several members were illegally detained, tortured, arrested, and the NSS was also projected as a frontal organization of the Maoists under the UAPA in an effort to ban them and disband their functioning. Fast forward to 2023 August. Since 4th of August 2023, I mean, there have already been massive constructions of roads through the hills already in an effort to, begin the extraction process and start get the refinery running again. But since 4th August, and now we're about a month and a half in, particularly in Kashi, there have been fresh attempts to hold public hearings for new proposals in the area, as well as to revive the Vedanta project through its proxy corporation called the Met. For the past month and a half, there have been disappearances and abductions and torture of over 20 persons from Kashipur, some of whom were later retrieved from as far away as Dantewada in Chhattisgarh. One person, out of fear of this abduction, jumped from the terrace and sort of injured their spine. Others were later either shown as arrested, this was after a week or 10 days, either shown as arrested or released to be brought back home, but all of them unanimously having faced severe torture in the process. At the moment, 21 persons are in jail, facing charges of attempt to murder because there was a protest against the earlier disappearances, and then the police sort of tried to disband and attack the protesters at the time, and that has been converted into an FIR for attempt to murder. There are also 9 persons from the Niyamgiri Suraksha Samiti who have been named in an FIR under the Unlawful Activities Prevention Act for unlawful terrorist activities. One of whom has been arrested, the others have not. Another person who is barely 20-21 years old has been arrested under a 2018 FIR on rape allegations, right, when this person was hardly 15-16 years old. As of and their bails have been consistently rejected over the past month and a half. Just 2 days ago, there was finally an announcement of public hearings that are now going to commence for these mining projects, particularly in Sijimali. So the public hearings will happen next month. And so the understanding is that the past month and a half of repression has been geared towards shutting down organizers, leaders, activists who could mobilize in light of these upcoming public hearings. You would see we've just circulated a fact sheet and a small leaflet which gives you an update about what is happening in Odisha, Raigada, Kashipur, Sijimali right now, with an appeal to please express solidarity and raise your voices. Very shortly over the next week we would also be circulating statements for endorsements, general public but particularly lawyers. So if you're interested, we would be happy to reach out to you to get those endorsements so we can get action both against these renewed efforts to divert Niyamgiri for bauxite mining, as well as these illegal detentions, torture and arrests of activists in the area.
Thanks, Radhika. So just we can go to the next slide. Coming back to the issue of the challenge to the constitutional validity of the Forest Rights Act in the Supreme Court. So in 2016, actually, the Supreme Court started what was called a final hearing, which actually didn't turn out to be a final hearing. They just heard the matter a lot on a preliminary issue. But interestingly, by this time, because the petitions had been filed in 2008, this is 2016, a number of the very senior conservation organizations, very highly respected conservation organizations like Bombay Natural History Society, had actually withdrawn from the case and asked for their names to be deleted. They did not want to be associated with the challenge to the FRA anymore. And so there's this organization called Wildlife First that took the lead. And they raised a very, I mean, it's interesting, but it's also very awful in terms of, how legal interpretation can happen. So what they argued was that to file a claim under the Forest Rights Act, you need to, especially a claim which is a claim for cultivation land, you need to show that you are in possession of the land on a certain date, which is December 2005. So a person who has filed a claim has admitted that they are in possession of the land. So their claim, if it is rejected, that means their possession of that land is illegal, and therefore it is an encroachment, and therefore they should be evicted. So bizarrely, suddenly in 2016, we found we are back to the 2002 position, where again there is this move to try and evict people, and just by getting an order from the Supreme Court saying rejection of claim is equal to encroachment is equal to eviction, whereas actually the law relating to evictions is very different. It's complicated. There is a due process that has to be followed, and there is no logic to saying that just because your claim has been rejected, you're by definition an encroacher on the land. It could have been rejected for a number of very invalid reasons. So the Supreme Court did pass an order saying the state governments should file an affidavit giving an data on how many rejections and the extent of land. But by that time we knew that this kind of order can again be interpreted in the same way as the 2001 order. So within like literally 5 days, the Ministry of Tribal Affairs at that point of time issued a circular to all the states and union territories. This time, of course, they cannot tell the states that don't file an affidavit in terms of the Supreme Court order. But they said when you file this affidavit, also please tell the Supreme Court that we have been telling you for the last 8 years that you are rejecting claims on completely wrong grounds, such as the fact that if the person doesn't have a satellite imagery map, or the person has not been able to establish that as another traditional forest dweller that he has been in occupation of that particular piece of land for 75 years. And in fact, there was even a government of Karnataka had at one point of time asked the ministry whether the evidence, whether a person has been in occupation of forest land for 75 years, whether that evidence also should be 75 years old. So this kind of nonsensical things have been happening. Please tell the court about all this also. So the message went out everywhere. No evictions are to take place. If you can take the next slide. But unfortunately, in 2019, the situation had changed a lot. And what had happened was that the lawyers had changed. Many of the lawyers had moved. I myself, fair disclosure, I used to be the lawyer in 2016, but I wasn't in 2019. One had moved on, the government had moved on. And so these are just little clips from the order that was passed in 2019 in February, 13th of February, where the court, here this is just the Andhra Pradesh part, where they said that let the Chief Secretary file an affidavit as to why the orders of eviction have not been carried out so far, in respect of the incumbents whose claims have been rejected, and let action be taken on or before the next date. And subsequently they had also given time of 4 months. Yeah, do the needful within 4 months. So now this was an actual eviction order, and it's a 35-page long order in which this is just the Andhra Pradesh portion, but they named every single state. Andhra Pradesh, then A, B, C, D, they went all the way down. And same thing, let the Chief Secretary say, let this Director of Tribal Affairs, Mr. So-and-so say, and why have you not carried out eviction? So as you can imagine, it was a real shock, because in 2001 there hadn't been an eviction order, but this time there was an eviction order, and it said 4 months time. Now fortunately, perhaps we can say fortunately, if you can say next slide, elections were around the corner. So there was absolute mayhem and mobilization across the country on the streets. with the politicians, inside political parties, outside the offices, absolute mayhem, huge mobilization. And eventually, within like literally 13 days, the government of India had to file an application for modification, saying we're very sorry, we were not there in court on that day, we could not tell you that actually you cannot evict tribals like this, and and then of course the judge rebuked them, saying really it's not right, you don't come to court. So then they modified the order and they said, however, we keep the order on hold as far as eviction is concerned. So that was a big relief. This hold order continues till today. So as far as the Supreme Court is concerned, they passed an eviction order within 13 days. The people managed to get it put on hold. Evictions did not take place as a result of this. This Forest Survey of India part I leave out because we're running out of time. So if you can just go to the next slide. What we needed to do actually, because there was so much confusion on the ground and there was literally panic, and what was very important for all the movements who've been fighting for the Forest Rights Act for all this time is that now people are going to say that filing a claim and getting it rejected, it puts you on a worse standing, on a worse footing than not filing a claim at all. So we are not going to file claims. And actually Forest Rights Act even till today is nowhere near saturation point. There are some estimates which say that as far as community forest resource rights are concerned, we've only reached 3 to 4%. And as far as individual rights are concerned, we've reached only 13%. So that 40 million hectares number that I gave you in the beginning, we're nowhere near that. But people have stopped filing claims. So that's a really bad message for the movement which has fought for this legislation. So literally I think we worked day and night, Radhika and I, and we were on the phone with all manner of people having all kinds of discussions, and we came out with a pamphlet which basically was a 2-pager saying what does the Supreme Court say, what does this order mean, and what is it that you can do. And of course we had some creative this license with that, and we said that there is no such thing as a final rejection until the Gram Sabha says that the rejection is final. And and you can't just base it on the figures that the state government is giving you that so many claims have been rejected. And we were able to put this out very quickly. It was translated some by friends, some people on their own voluntarily into several languages, and people were in their rallies and protests that they were having, they were just circulating this, and we were grateful for that, that we could put this information out very quickly among the people. So this is one thing that we are all very proud of. So finally I just want to show a couple of slides. I'm right about to end. If you could change the thing. So what we are seeing today is that although there continues to be a lot of attack on the Forest Rights Act, for example during COVID, in spite of the fact that there are these stay of eviction orders of the Supreme Court, in spite of the fact that the courts were closed, people were not coming out of their houses, there was very real fear, especially during the first 2 lockdowns. After that people started becoming a little less scared about coming out, and those few months are the time when the forest department was out into the forests doing forcible plantations of campa plantations on the lands of the most vulnerable tribals. So they would go out and pick on the particularly vulnerable tribal groups, or on say the the tribal groups who are not recognized as tribals for whatever reason, they are OTFDs, so their claims have been stuck, and people are not able to even get out of their houses and challenge them. And if they did come out, then they were all sort of, why have you come out? You are violating that, what was it called? That Diseases Act and all. Epidemic diseases. Yeah. So it was quite horrible. And so at that point of time, if you can just go to the next slide, we'll come back to this one. So what we did, because we were also stuck at home, working from home, we didn't know what to do. So what we basically, everybody was saying, what do we do, what do we do? And I said, the only thing you can do is pass Gram Sabha resolutions, hold a Gram Sabha meeting and pass a resolution, because what the forest department is doing is not just contempt of court, but it's also a criminal offence under the SC/ST Prevention of Atrocities Act and also under the FRA. So pass resolutions, at least have the records there. So everybody is asking us, how do we write a resolution, how do we write? So then we just published this little booklet, how to write a resolution. Here is a draft resolution, how to write the covering letter. Here is the draft covering letter. Send it by post, keep it, if the post office isn't taking it, do this. You know, so, and then that also has got translated into some 5-6 languages and has gone out. So, and people have just taken it and said that, you know, okay, you've got all this stuff about the Legal Resource Center and what they do and all. We're not interested in all this. Can we just translate the relevant portions and circulate that? And we were too thrilled by that. If you can just come back. So if you see here, across the country, there are these proactive movements taking place. One is, of course, the Pathalgadi movement. Many of you have heard about it, where, you know, there are these traditional sort of rituals and customs which they have now adapted to the constitution and the FRA. So if you read this carefully, you have Bharat ka Samvidhan, and then there is the Gram Sabha scheme, and then they have quoted provisions from the constitution and from the Forest Rights Act. And they say we are asserting now that this is the law that should be followed in our village. And many people who did this were actually also arrested. In the other picture you see women who are tying this red cloth as a promise to protect. You know, so it's like a reverse thing of the Rakhi, but saying that we will protect you. And this of course is a young man. We've done training programs when we do, especially in the communities and the tribal communities. We make it a point to give them a copy of the constitution, even if they are, you know, like neo-literates. And we have found that people are really emotional to hold a copy of the constitution in a language that they can read. It's a wonderful experience. So finally, I just want to play one clip actually. It's called Chhattisgarh something.
No, this one, the footage Chhattisgarh.
So before you start it, let me just give a little background. So this is a village of other traditional forest dwellers in Chhattisgarh, and they actually didn't know that they can file claims under the Forest Rights Act. Until one day they had come for one of our trainings and got hold of that little booklet, and they were sitting in a corner and reading it and saying, you've repeatedly written Anya Paramparagat Vanyavasi, what does this mean? And then our colleagues, they told them that Anya Paramparagat Vanyavasi means other traditional forest dwellers who have rights under. They said, but the forest department has been telling us for the last so many years that you are non-tribals, you cannot get rights under the FRA. So imagine that entire fight that we fought to get ODFDs included, the forest department is just, you know, erasing that part of the law by just simply telling people a lie. So then they got hold of this, then they filed their claims over this forest. Then the forest department said you can't file claims on this forest land, because all this while they couldn't file claims because there were other traditional forest dwellers who don't have rights to claim over forest land. When they filed their claims, they said, but this land has already been sold to Jindal. So they said, how have you sold it to Jindal? You said it's forest land cannot be sold. So then they found that there have been all kinds of ghapla in the papers, and they did go to court, they did get a stay order, but this is before the stay from the court. So I just want you to see how they are arguing with the forest officials who have come there to plant trees and to take over and do fencing on that land. Yeah.
सम्मान करने के
देखो पार्टी वाले जब हम दावा करें उस बात का जब तक हमारे मन के निराकरण नहीं तब तक बीच में कोई दूसरे नहीं और हर जगह आने
पूरा देखा समय भी होता तो तुम
हम कलेक्टर थोड़े
मिली देखा
निराकरण हुई तो छोड़ दे
नहीं तो शुरू तो सरकार के कानून के खिलाफ जाते हो
कानून सरकार बनती है
कानून में तो लिखे है सरकार है वन अधिकार पूरे कानून में लिखे है
So it's Chhattisgarhi Hindi, it's a little difficult to understand, but basically what they're telling the forest officials is that we have filed claims including our community forest resource claims, and you cannot come here and take over the land because according to the Forest Rights Act, the Gram Sabha is the Sarkar, so you cannot use this land without asking us. And when have you asked us? And when they say what rubbish are you talking, and they're pulling out their claims and showing it to them and saying don't try to break the law and this thing. So this I think, you know, so the reason I'm showing this to you is because very many times when we talk about lawyering, we are thinking about that lawyering as, you know, like I am a lawyer in the Supreme Court and all that. But look at this woman. I mean, look at the way she argued and held her sort of cool, and she had her papers, and the thing that I really find, this is I think a year ago, that 3 people are doing recordings. You know, so the situation that happened in 2002, where we have no footage, no evidence, no photographs of the kind of very violent demolitions and destruction that took place. We don't have, people are, the government is trying to, the state is trying to hollow out the Forest Rights Act, but it has literally captured the imagination and the hearts and the minds of the people on the ground, and I don't think that it's going to be that easy for them to turn the clock back. So just to end, I want to show that last picture. There's one very last one. These are women from Berhampur in Orissa, and this forest they had been protecting as a community for many years and nurtured it, and it turned out that it was actually not a forest land at all in government records, and the government had sold it off to a liquor factory. And these women, they did the same thing as the Chipko women, and they managed to get the chief minister to withdraw the order. And so that's it. I mean, that's it. I mean, for me, yeah, lawyering means at the end of the day, the women on the ground are fighting that fight.
Absolutely fantastic, and I'm so glad we did this through the archival method, because it allows us to tell a story, right? And I don't think we, like usually in lawyers' offices, we don't do storytelling like this. So I'm not going to hold. I think we can just move straight to Q&A. But I just wanted to share a small anecdote before that, which is after the eviction order in February 2019 came out. So like Shomona mentioned, everybody mobilized in an instant, right? So people were out on the streets, people were meeting their representatives, people were, passing resolutions, etc., etc., etc. Which is why, 13 days later, you had the central government, going to the Supreme Court and saying, no, we are not going to evict. And that hearing was just really funny because so you had sort of these wildlife organizations who were the petitioners, conservationists on one side, and then you had, all of us, these sort of autonomous human rights organizations, Adivasi organizations on the other side. And the hearing has just about started, and of course to represent the government, the ASG needs to show up. ASG at that time is the same one as today, and this is Tushar. He hustles into court, right, and goes and stands on the respondent's side. And then he takes a pause. He looks to his left, finds Nitya Ramakrishnan. Looks to his right, finds Sivu Singh. Looks back, finds other human rights lawyers. Then he looks at his podium and he says, am I standing on the right side? Do I need to be on the other side? It was a penny drop moment for me. Like, no, we are on the same side today. But anyway, yeah, so I think, thank you to Shomona for this very, very interesting storytelling. I'm not going to hold up anymore and just open up to questions and everybody else.
So legally, is it true that any land that is declared as CFR under the FRA, community on the land, cannot ever be diverted for any other use? No, that's not the case. No. That's there for critical wildlife habitats under section 4.2. There's a proviso, but not for community forest resources.
So anything that's declared critical wildlife habitat under the FRA,
yes,
cannot be diverted.
Why do you think we don't have a single critical wildlife habitat?
That's why BRLs was going to be one.
Yeah.
That's why I asked. And there was this whole rumor that even forest department was like, हम इसलिए कर रहे हैं, हम इसको कभी divert नहीं करेंगे. ये CFR में, it will be permanently everyone's win-win situation. Of course, that didn't happen. But they claim that legally it's a win-win situation for them, forest department as well as Adivasis.
Yeah.
So that's why I didn't know. I mean, I didn't know who to ask. So I'm lucky that I'm able to ask you this question and get clarity on it. Thanks.
I have a question. I'm not a lawyer, but so I work like a little bit with the Solika tribal community in BRS. Not much, but very little. But still, so one thing I realize is that to recognize, one is to recognize legally their right of land, but the other is to recognize their the value that the knowledge system gives to the to being custodians of the land and custodian of the like biodiversity and ecology and conservation. So while land is a tangible entity, the knowledge is an intangible entity. So it's much more difficult to protect legally. So because of that, I mean, a lot of the knowledge is kind of now it's more academic. It's not their own knowledge is not really coming out very strongly. So like within their language, like embedded in their language, embedded in their living systems, there's a lot that you can take from and you can really learn from, and you can like their own ways of living are directly translatable to the protection of that very land. So I mean, legally, what is being done from that perspective?
Very little actually. The reality is that in the list of forest rights which is there in section 3 of the Forest Rights Act, one of them is intellectual property rights. But the thing is that when we're looking at knowledge as an intellectual property, that's itself like it's contradictory when you're talking about Adivasi communities, because their notion of property itself is very different from the mainstream notion of property. They look at land as not something that belongs to them, but something to which they belong. And so they have the same relationship with knowledge. And I think this is one area in which it's very important to recognize that we may not be actually able to find the solutions in the law, because from what I've tried to show to you, maybe one of the things that I should have said is that this is representative of very deep and entrenched prejudice against Adivasi communities. That something is, that there's something wrong with them because they want to live in the forest and they want to. I mean, I've actually heard judges say, and it's now creeping into judgments where they talk about Adivasis as being uncivilized and there's a need to civilize them. So that kind of mindset is there, and we've had to struggle to just ensure the bare minimum, that you don't evict us. But this, what you're talking about, is something more than that. It's more wholesome, and I think there's a need for people to start those processes and not wait for the law, the legal system to come up with those solutions, because it probably never will.
The other question I want to ask is, like, a large part of the legal system recognizes forest and land law itself by the method of cartography, which is like very like a colonial practice, which didn't recognize a lot of. It started with that practice of the tribal dwellers don't have enough knowledge, so the map itself was flawed, and the legal system is based on that map. It bases the law on that map, which is flawed. So like when people, so I think like A3 recently made a counter map of the DR hills, where they made a map of. So when you are trying to when maps like this are made, what is the process for it to come into the legal system?
So in fact, the Forest Rights Act itself, it's great that you asked this question, because the Forest Rights Act itself provides for communities to make their own hand-drawn maps and use those maps as supporting evidence for their claims. They don't have to use the cartography maps. They don't, and in fact, there are judgments which say that if you insist on satellite imagery maps, that is illegal. It's contrary to law. So, this is the first time where you don't have to go to the Patwari and get the map out. If he's not giving the map, if he's giving it, good. If he's not giving it, the forest department doesn't share the maps. Doesn't matter. They make their own maps. And so we have, claims which come up with these very colorful maps with, the houses drawn in red and the sky in blue and the rivers in whatever, and also these very colorful hand-drawn maps. But this is the map, and now it's up to the state to convert that into a map that fits into their sort of whatever mapping systems. So, and that has a legal status, that map.
I've not been in touch with these movements, but I do know of the Nagar movement that's happening now, and for years, but coming to the light now. So that was, the communities were taken out of the tiger reserve, and I want to ask, what are the kind of evidences used to say that human and wildlife cannot coexist? What exactly are they claiming, or why are they claiming that?
In fact, that you pose that question is interesting to me, because it is not that evidence is required, but although the law says that to declare a critical tiger habitat or a critical wildlife habitat, you have to show that coexistence is not possible. But in the way the law unfolds is that this is understood. So now the burden is on the people to show that coexistence is possible. It's the other way around. It is understood, it's a given, that large animals like elephants and large cats like tigers and lions and leopards cannot live with humans. Now you establish, you try to displace that. Burden of proof is on you. So that's how it operates. It's not supposed to be like that. It's scary, yes, it is.
Thanks for the presentation. Really fantastic, I think. Just to get a sense of how the way the Forest Rights Act is really owned by communities. So that was really very powerful, because often you don't get that. You don't get that sense unless somebody like you comes in and talks about it. So I think that's very educative for everybody here, I think. One question I had is I don't know if you've seen this book called the Arnold's favorite book, Founding Mothers of the Indian Constitution. Actually, it looks at the 15 women members of the Constituent Assembly. What are the issues they brought up? I was thinking similarly in the Constituent Assembly, in terms of the Adivasi community and how their interests were represented in the Constituent Assembly. One figure, of course, is Jaipal saying, really, almost, I think, very brilliant articulation in terms of, what an Adivasi perspective could mean. So the space for that kind of a research, getting together something which links up both the history of the Constituent Assembly as well as this contemporary moment. Right? The entire question of how a law gets owned by people, and that's your point of maybe 5th schedule, maybe 6th schedule, Forest Rights Act for sure. There is judgments you spoke about as well, and the Patalgadi movement. It's a really powerful account of how there's a symbiosis between the law and the movement, really. And it's because you look at the comparison, right? I mean, just now there was a reading of the preamble on the steps of the town hall, and you see the range of people represented there. They broadly say the liberal, secular, leftist, minorities, those people who see Dalits. The groupings are very invested in the preamble, right? But from Adivasi perspective, it's very interesting. It's a very different idea of the constitution. So it's like, you go beyond the 5th schedule. And that's again the question to constitutional law scholars, right? I mean, why don't you teach the constitution from the perspective of the 5th schedule? There's a lot to be done there, there's a lot of work to be done. So sorry, just a series of reflections, just thought. Thank you very much.
Yeah, so it's interesting you also mentioned about teaching. So there are 3 second-year students from National Law School, and we're doing constitutional law. And we looked at the Orissa Mining Corporation case two days ago, just 2 days ago. And but we didn't look at it under the rights provisions. We studied it as part of local government. And as Arvind said, so it's 5th schedule, 6th schedule, but also Gram Sabhas. Something that comes out very strongly in what you say is in that video that you showed us, when people are doing this, that we get to make the law on this. So we also studied, we studied the end of a depressing lot of cases where under local government law, not much has really happened because they don't have financial powers, they don't have other things. But under the Forest Rights Act, there is this provision where Gram Sabhas suddenly become quite powerful. We had a discussion in Karnika also here. The point was, what's the point of decentralization by itself? and she's absolutely right in saying, in the other context that we know, and we read this wonderful book by a chapter by K.C. Sivaramakrishnan, who was one of the main movers of the 73rd and 74th Olympics. So in this general sense of despair that local government really hasn't taken off, that idea of Gram Sabhas under this particular situation, and this case really shows you, you're looking at, Aftabanam was on the bench, he didn't write it, it was
Radhakrishnan.
Yeah, Radhakrishnan, Aftabanam, the 3rd judge, and he was sort of considering that and trying to get this answer. But just on the point of perhaps Gram Sabhas, maybe you could tell us a little bit about how that's a different note than the generally sort of this account that local government in India doesn't really work in the regular way that we're supposed to.
So the idea of the Gram Sabha is actually not new in the FRA. It is from the Panchayats extension to Scheduled Areas Act. And in fact, there are several references to the PESA. They are kindred spirits actually. And the definition of village, the definition of Gram Sabha has been taken from PESA. And what actually is interesting is when you talk to people who are like in their 70s and now who were part of the struggle to bring Pesa. They actually feel that after Pesa was brought in, then the Samta judgment came, there was a lot of enthusiasm. But then for whatever reason, Pesa somehow didn't work. I mean, there are structural reasons why it didn't really work the way it should have. We won't get into that. But what FRA has done is it's just brought new life into that old idea, and also taken that idea out of the scheduled areas into the forests across the country. And what we are seeing, in fact, on the contrary, rather than local self-governance fading away, is that because Gram Sabhas now actually have something to do and they feel a sense of empowerment, they feel a sense of recognition, they have actual work, hardcore work to do, is that people are actually coming together, and this whole process of filing claims, sitting together, talking about what were our traditional boundaries, and that map making exercise has been very, very powerful, because we have, for example, young people from Adivasi communities who know how to use smartphones and GPS and things. So they go out during the day and they sort of go and do their mapping and take photographs and all, and they come back in the evening, and then the village elders who can't walk, they show them that, okay, this is the mapping that we did, and then the elders will say, why have you put this point here on this side of the river? It is supposed to be on that side of the river. Go back. And so there's this beautiful sort of community developing. So there is an actual resurgence happening of the Gram Sabha at the local level around the
Even that video where you on the district judge, I think that was very, very striking. You are challenging state authority, and as you said, good in this case that the district judge, maybe he was being photographed, so he was a bit, milder.
So because he was there on the orders of the Supreme Court, so he couldn't really.
But he's trying to negotiate. But they're openly challenging and saying this part is also there, that part is also there. Very clear that they're also empowered in the sense of making claims against the state. And in the other instance, they are asserting that they are the state. Right? That was even more striking in the videos that you have. Thanks, very powerful.
And since you're talking about having studied the Niyamgiri judgment, so I have to tell this story about when the hearings are going on before this 3-judge bench. And you remember that part where he's saying that the mountain has, just like a human has head and hands and ears and nose, and the mountain also has different organs. So how can you say that this part is not Niyamgiri and that part is not Niyamgiri? So in court, the lawyer appearing for the mining company actually said that what kind of God is this? That God doesn't have a temple, God doesn't have a shrine, God doesn't have any statue, and is not located anywhere. One full mountain is only God. And it was the judge, I think it was Radhakrishnan or Aftabalam, I forget who it was, who actually told him that, the Adivasis have a different spiritual practice. And you have to respect that. Just because it doesn't fit into your idea of what God should look like, doesn't mean that it isn't as meaningful for them. So that just helps in setting the
In fact, I was just Astha is also here. She's also with the Legal Resource Center. And for the past 5 years.
I don't remember how many.
We've been trying to work on this paper about exactly what you said, which is, I think it's perfectly appropriate to teach MOEF not through rights but through a self-governance framework, because there is a history preceding the Forest Rights Act and Section 5 of the Forest Rights Act, and although in some ways it's the forest rights, it doesn't use the word consent, right? But that's the direction that the Niyamgiri judgment sort of pushes the law into. And Astha and I started with this idea of free, prior, informed consent. What does that mean, etc. And then when we began, tracing the antecedents of the Gram Sabha's autonomy over land, right? We said that consent is such a reductive framework to view it through, right? And I mean, it has to be viewed through the lens of autonomy and self-determination, which is what the fifth, right? And there's a history too. Before the FRA, there is the PESA. Before the PESA, there is the fifth schedule. Before the fifth schedule, there is the CNTA, SPTA. You have the partially excluded areas, right? So I mean, in some ways, even the idea of talking about the Gram Sabha as a local self-government institution is doing it disservice, right? So if you look at what happened in the Pathalgadi movement, right? So the stone slabs that we just saw, which started in Khunti in Jharkhand, and then there was a massive crackdown. But then it spread across all of eastern India, right? All across Jharkhand, Chhattisgarh, Odisha, even Gujarat, MP, Rajasthan, right? So where people were erecting stone slabs around their village boundaries to say, not just that this is our land, but our laws apply here, right? It was more than that.
And when they say our laws, they're not saying laws that they have written down sitting as a Gram Sabha. They're saying our laws as written in the Constitution,
right? So they're drawing back to the fifth schedule, they're drawing back to the CNTA. So
and their interpretation of the Constitution.
Of the Constitution as well, right? So it's not a local self-government in that sense, right? It's very much like a sovereign, semi-sovereign entity that is asserting its claims of governance, territory rights, whatever. Okay, so maybe and we can perhaps keep this discussion going at a future time as well. But thank you again, Shomona, for bringing us to a note of hope and ownership and struggle. And at some level nudging us out of the despair and cynicism that we've all been struggling with for so long now. And thank you again to Kamra, ALF and NCBS for bringing us all together today. And with that, perhaps we can close.
Thank you.